Going back to the fifth order, this is an order authorizing the execution of an agreement for termination of property management agreement with Ridgecrest Investments relative to the management and leasing of portions of the Memorial Campus and setting the termination date to be effective 5 p.m. on May 31st, 2012. And with that, I will turn it over to City Solicitor Mike Cohen.
As you all may recall, back on November 24th, 2009, the Mayor and City Council entered into a property management agreement with Ridgecrest Investments, Inc. for the management and leasing of portions of the former Memorial Hospital campus. And based upon the request of the Mayor and Council, I contacted Ridgecrest relative to terminating that arrangement, and Ridgecrest is cooperating in regard to the process so that we can terminate the agreement effective May 31st, 2012 at 5 o'clock p.m. With the termination of the agreement, the management of the facility would be turned over to the city, but as a result of the management being turned over to the city, there would be no revenue sharing with Ridgecrest. Basically, all the rents that are derived from the leasing of the Memorial Campus would go to the benefit of the city. The basic terms of the agreement are as follows. In essence, the agreement provides that all the leases that were entered into by Ridgecrest on the city's behalf are assigned to the city. It's probably not necessary, but we wanted to make sure that it was clearly indicated that the leases are for the benefit of the city. There is a mutual release provision that provides that each of the parties release one another from any liability in any way related to the property management agreement. So each party releases the other. Going forward, there's no liability on the part of the city to Ridgecrest and no liability on the part of Ridgecrest to the city, except as may be provided under the terms of the termination agreement. One of the instances where there could be some indemnification from one party to the other is in the event that a tenant or third party after the termination date files suit against either Ridgecrest and or the city for actions that occurred during the term of their lease. Insofar as the actions were the fault of Ridgecrest would be responsible for indemnifying the city. But reciprocally, insofar as the acts or omissions which led to the filing of the claim are as a result of actions by the city, then the city would be responsible for indemnifying Ridgecrest. Of course, Ridgecrest is going to have to vacate the premises. It will. There are provisions in the termination agreement relating to representations and warranties regarding the presence of hazardous materials on the site that Ridgecrest is making for the benefit of the city, to the best of his knowledge, information, and belief, and basically to the best of his knowledge, information, and belief, there aren't any issues that are on the premises. As you all may or may not recall, under the terms of the property management agreement, Ridgecrest had the exclusive option to purchase the Memorial Campus property, and as a result of the execution of the termination agreement, it is going to lose the purchase option, so it will no longer have an option to purchase the premises, an exclusive option. So the possibility that the property could be sold to a third party will not be foreclosed. Part of the agreement is that Ridgecrest is going to cooperate with providing the city such documentation as it may request relative to Ridgecrest's responsibilities as the property manager during the term of the property management agreement, and provide such documentation as the city may request from time to time. And then, other than that, there's some other terms that relate to legal issues, not necessarily substance.
Okay, with nothing being withheld, could I have a motion to approve all 6 items as a consent agenda?
So moved.
Second.
There's a motion and a second. All those in favor?
Aye.
Thank you very much.